We are now in for what I call an additional educational treat. In addition to being the former NGAUS chairman, General Don Dunbar is an attorney and a passionate student of Guard history, especially the legal framework of our institution. He has researched the legal foundation of the National Guard and is here this morning to share his knowledge with each of you. General Dunbar has given this presentation to several audiences nationwide, and I think you'll find it very enlightening. In fact, he gave this presentation to us when he was chairman. And I will tell you, Don Dunbar is more than a former chairman for this organization. He helped mentor a lot of young men like me who came into the TAG position newly, I guess, frocked with that position, to educate me as I did my job. And so I'm not only introducing you to a former chairman, but also one of my mentors in this job. So Don, welcome to the stage, and we look forward to hearing your presentation this morning. General Don Dunbar.
Good morning. Well, I used to say my name's Dunbar and I'm a guardsman, but they kick you out every once in a while. And I will tell you though, I am passionate about the National Guard, and it is my privilege to be with you here this morning to share our story, the legal framework of the National Guard. The National Guard is the foundation of our nation's defense. And I want you to know it was the specific intent of our founding framers. It is an unfortunate truth that here in 2023 that the vast majority of our nation, including elected leaders, business leaders, even senior military leaders, really don't understand the National Guard and the framework under which it was created and under which it operates. So why talk about that today? Well, it's timely. You probably know this, but during COVID, there was some tension between DoD and the states regarding COVID vaccine requirements. Some states sued. I'm not here to lay in on that debate, but I will share with you that the Fifth Circuit Court of Appeals issued a ruling not too long ago that in part of that case heavily favored states' rights and some of the things we're going to talk about this morning. And now it's not clear if DoD is going to appeal to the Supreme Court, but they might. But in the meantime, the Fifth Circuit's opinion is substantive and it's compelling. The Army Times followed up with an article in July covering the case and offering a good perspective from several quoted experts who imply that the federal control of the National Guard might be going away. Wow. I'm not sure what's more problematic, the quoted belief that the Guard is fully under federal control or the fact that the Fifth Circuit could end it with just a ruling. So, knowledge is power. And for this organization, we need to understand fact from fiction. But the topic is complex, and I only have a little bit of time, so I'm going to move fast. So buckle up. To tell this story, we're going to cover some history, we're going to explore the Constitution, and some legal evolution. And this information is important to put that issue that I just raised in context. Emerson wrote, "By the rude bridge that arched the flood, their flag to April's breeze unfurled. Here, the embattled farmer once stood and fired the shot heard round the world." This picture you're looking at shows the bridge over the Concord River, where the Minutemen assembled and fired that shot. Across the bridge in the distance on the right, you can see the Concord Minuteman Monument, a farmer who's leaving his plow behind and picking up a musket and responding. It's impressive. But how did we come to have Minutemen ready to respond in 1775? To understand, we need a little bit of historical context. Our militia heritage begins with the British concept of every able-bodied man defending the community. This is the militia. It becomes unique on this continent in 1636 when a Massachusetts court orders the creation of 3 specific units and orders them to drill and assemble more often. These units were a subset of the militia. Now, during this period of time, Great Britain relied on the militia to protect its interests. There was no standing army. There would be no standing army for well over a century. The militia supported Great Britain in the World War of 1754. You may have heard of this as the 7 Years' War, perhaps the French and Indian War. On the left, you can see how North America was carved up by European powers, and on the right, how Britain had prevailed over France by 1763. But early on in this conflict, Britain suffered setbacks to the French and their allies. In response, the king sent a regular army to the New World. This was unexpected, and the colonists were assured that the army would leave after the war was over, but the king, he reneged on that promise, and the army remained. Predictably, the standing army proved abrasive and offensive to those earliest citizens. This led them to file an indictment against the King of England. You may have heard of this indictment. It was called the Declaration of Independence. Now, we all know Jefferson's words. Who can forget? We hold these truths to be self-evident, that all men are created equal, endowed by their Creator with certain inalienable rights, and that among these are life, liberty, and the pursuit of happiness. But many of us have forgotten that in the heart of this document are 27 allegations of crime, 2 of which specifically apply to a standing army. Now, during the period between the 7 Years' War and the Declaration of Independence, as the British Army remained and tension grew, the leaders of Massachusetts, just like that court order in 1636, they carved out a smaller portion of the militia and kept it at a higher level of readiness. And this is how we came to have Minutemen prepared in 1775. Britain surrendered in Yorktown in 1781. The Paris Treaty in 1783 created the United States as a sovereign nation on the world stage. It's one of history's great stories. But 6 days before that treaty was signed in Paris, the Congress, not the one we have today, but the one under the Articles of Confederation, was trying to figure out how to defend this new country, and they created a committee led by a guy named Alexander Hamilton. That Hamilton. And he wrote to General George Washington, and he asked him, "Sir, what advice have you got for our Congress on how to defend this new nation of ours?" Washington took this query very seriously. He reached out to his senior leaders, Generals Knox, von Steuben, Huntington, Pickering, Heath, Hand, Putnam, and his good friend, Governor Clinton, and he asked them for their advice. Washington then synthesized this advice and in his own hand responded to Congress with a document called the Sentiments on a Peace Establishment. He referred to the militia as the palladium of a free people, with palladium meaning the essence of defense and security. Washington advised Congress with these words: we need a small standing army. We need to rely on the militia. We need a subset of that militia, just like the Minutemen, to be ready at a moment's notice while the rest of the militia gets trained up. And we should establish military institutions to study war, so think West Point. Congress then appointed a committee to improve the Articles of Confederation, which ended up with a new Constitution ratified in 1789. With this as our background, let's look at what the Constitution says about national defense. Our Constitution created a limited, I say again, limited federal government, with a few simple missions, none of which has a higher priority than providing for the common defense. To provide for that common defense, the founding framers debated at length whether to defend our new nation with a standing army or the militia. The debate, which was captured in the Federalist and Anti-Federalist papers, had passionate advocates on both sides. Brutus wrote in Anti-Federalist 24 that standing armies are dangerous to the liberties of a free people. Hamilton wrote in Federalist 25, "Here I expect we shall be told that the militia of the country is its natural bulwark and would be at all times equal to its national defense." This doctrine, in substance, had like to have lost us our independence and cost millions to the United States that might have been saved. So some felt that any standing army would be offensive to our liberty, while others felt that trusting our defense to a group of unprofessional rabble, that would be you, would invite disaster. Now, for the record, I would have told Hamilton that the militia is the natural bulwark, and I would have debated him anywhere, anytime, including a theater in New York, without fear of losing that debate. Now, we don't need to study that debate in its entirety, but we, as an association, need to understand this was a big issue. In the end, to agree on ratification, the framers reached a constitutional compromise. They settled on both a small but scalable active duty army and a reliance on the militia. It is clear from our history that without this compromise, key states of the original 13 would not have ratified, and the United States that we know and love and serve would not exist in its current form today. This compromise endures in our Constitution. It can be seen in the enumerated powers for our Congress and our President. Congress has a war power to declare a war. They have tools. They raise and support armies. They maintain and provide a navy. And they make the rules to govern both. Separate from the war power, Congress has a militia power to provide. For what? To call forth the militia. To do what? 3 things. Execute the laws of the Union, suppress an insurrection, repel an invasion. They also provide to organize, arm, discipline the militia. And then they govern the militia when it's in federal status. And the Constitution reserves to the states, as you see in that last line, the appointment of the officers and the authority, not a split authority, the authority, to train the militia according to the discipline prescribed by Congress. The President is our commander-in-chief, we all know that. Of the armed forces, it says the Army and the Navy. And the militia when called into the actual service in the United States. So from our beginnings as a country, the Constitution reserved substantial power over the militia to the states while providing for the federal government to mobilize them or call them forth when needed for the good of the country. Both the President and the Congress have full power over the militia after they are mobilized. Now, here's a rough depiction of what our basic framework looked like in 1789. On the left, this is your war power. On the right, this is your militia power. Here's a rough depiction of what it looks like today. War power, militia power. Let's discuss how we got from 1789 to today. After the Revolution and ratification of the Constitution, Congress had a lot of work to get done. We had a lot of debt. We had to put some congressional language, some meat on the skeleton of our Constitution. And President Washington, newly elected, again advised that we should rely on the militia and keep a subset more ready. Congress considered this, but the price tag, are you ready? $400,000 was simply too much money for Congress at that time. So what did Congress do? Well, for the first 115 years of the Republic, the states operated under the Militia Acts of 1792 and 95. This was intended to ensure a uniform militia across state boundaries. Given what we just covered, it will not surprise you that these acts provided law and resources to do 2 things. Provide for calling forth the militia, so they gave the president the authority to call them forth for 30 days, and to provide for organizing. So think, just like the Army, division, battalion, company, so many officers, so many enlisted, To arm, they told the militia, go out and buy yourself a weapon and be ready. And discipline, and don't bite on this one. Don't think Uniform Code of Military Justice. The discipline means training, and here Congress applied to the National Guard the same standard as the Army, which was General von Steuben's Blue Book from 1779 in the Continental Army. However, despite these laws, Congress actually provided very little in terms of resources. The net effect was that the states largely funded the militia, and therefore the states chose structure, arms, training standards. Some states did this very well. Other states, not so much. And it caused challenges when our nation called upon them. But call upon them, they did. In fact, from 1789 to 1898, the nation relied on the militia multiple times. The War of 1812, the Mexican-American War in 1846, the Civil War. The results, they were mixed. Now, we don't have time this morning to cover too many of these anecdotes, but you should hear a few. The first time we called out the militia was in 1794. It seems some people in western Pennsylvania objected to a whiskey tax. Who can blame them? But it was a problem. So George Washington called out 13,000 militia from Pennsylvania, New Jersey, Maryland, Virginia. And this is my favorite part. He got on a horse and led them. In 1814, the militia in Maryland and an active duty unit were charged with defending Washington, D.C. They were attacked by a much smaller professional organization, and the lines broke. The government was evacuated. The Capitol was burned. And the next day, the papers referred to it as the Bladensburg races because they said the militia ran so fast. A few weeks later in Baltimore Harbor, the Maryland militia would perform extremely well. But that story doesn't get told all the time, and it should. In 1815, the British tried to take New Orleans, and with it control the Mississippi River in the middle of North America. But they ran into a guy named Jackson and a well-trained militia from Tennessee, Kentucky, and Louisiana. And they crushed a superior invading force, one of the most lopsided victories in American history. There are many more stories I could share, good and bad, about the militia during this period. The key takeaway is that the militia, able-bodied men who were civilians and not professional soldiers, could and would respond as needed as long as they were organized, armed, and trained effectively. Now, starting in 1898, the militia enters a period of transition. This begins with the Spanish-American War, 1898, where despite a resounding victory over Spain, the militia is thought unreliable. Why? Because they're ill-equipped. Inefficient common standards across state lines. Leaders, including Teddy Roosevelt, argued that Congress should fix the militia. And by fix, they meant give them resources. So in 1903, Congress heeded the call. They passed the Efficiency of the Militia Act. This was a landmark change. But when you distill it, it was really just an adoption of what Washington's advice was in the beginning. Because Congress created the National Guard, a subset of the militia. The militia was now split, with the organized militia being the National Guard and the rest of the militia, all able-bodied men not in the National Guard, was the reserve or unorganized militia. This act, like the acts of 1792 and 95, reiterated a common federal training standard, just like the Army. However, unlike those acts, Congress provided substantial resources. Now, many claim that this act federalized the National Guard, but I don't think that's true. Congress simply provided resources and funding. Congress provides funding and requirements for a lot of things. They provide funding for roads, hospitals, schools, but it doesn't mean that the highway workers, the doctors, the nurses, the school teachers become federal employees. It just means the federal funds have to be used for the purpose for which they're provided. In this case, the funds were for organizing, arming, and training the Guard. But it didn't make the Guard professional soldiers. Despite providing federal funding for this specific purpose, the state's role in commanding, administering, appointing the officers, and conducting the actual training of the National Guard remained in effect, consistent with the Constitution. Over the next decade, the National Guard quickly became much more efficient in training and preparedness. Starting in 1910, the United States and Mexico engaged in an elongated border war. There was a debate on whether or not the National Guard, once federalized, could serve outside the United States. Concerned, President Taft asked his Attorney General, a guy named Wickersham, for a written opinion. Wickersham looked at the law, and he concluded, based on what we just discussed, that the National Guard could not serve outside the United States. Why? Different congressional authority. Under the war power, you can send the Army anywhere, send the Navy anywhere. Under the militia power, those three things are bound by our landmass and our laws, which only apply in the United States. In response to that opinion, continued tension with Mexico, and the outbreak of World War I, Congress passed the National Defense Act of 1916. The statute expressly provided that the Army of the United States would from this day forward include not only the regular Army, but the National Guard while in the service of the United States. The act required the Guard to take a dual oath to the President and to the Governor to support the federal Constitution and the state Constitution. And it authorized the draft of the National Guard for active duty service in the Army. The language expressly provided that when drafted for federal service, members of the National Guard were severed, discharged from the state militia, and from that date subject to the rules and regulations governing the Army. Note, this was a one-way action. This occurred in World War I, where most of the National Guard was drafted, served, and performed brilliantly. However, this law virtually destroyed the National Guard. Members of the National Guard were drafted not as military members of the National Guard, but as individual civilians. After federal service in World War I, former members of the National Guard were discharged as individual civilians. The National Guard was broken, and state leaders, just like this association, voiced concern to the War Department and to Congress. Congress recognized this as a national security problem, and they asked the War Department, what's the plan? How do we fix it? And the War Department had a plan. Let's get rid of the National Guard. What we need is an Army with 500,000 active duty soldiers and 500,000 federal reservists. It's quite a blow. Just imagine how the state and National Guard leaders objected, and they did. You know, it kind of reminds me of a story. There was a young man who graduated high school. Didn't know what he wanted to do, so of all things, he decided he was going to join a monastery. It's a tough life. You have to take a vow of poverty, chastity, and silence. Hard life. But he checks in, he gets indoctrinated, and they tell him he can say 2 words every 5 years. He goes to work. It's a hard life. 5 years go by. He sits down with the supervisor, and he says, bed, hard. And he goes back to work. 5 more years go by. He looks at his supervisor, and he says, food, bad. And he goes back to work. 5 more years go by. He sits down with the supervisor again, and he says, I quit. And the supervisor just shakes his head and says, you know, I'm not surprised. You've done nothing but complain since you got here. You know, after World War I, the Army was appropriately riding a high. They had done phenomenal on the world stage. And they were surprised that the states would object to their plan. According to the Army, the World War I had been perfectly executed, and our nation needed to move on from its militia roots. The War Department believed the National Guard had exhausted its usefulness. Our national defense should be 100% federal. But the states and the National Guard, they did object. And more importantly, Congress understood the National Guard just can't be eliminated. It would require a constitutional amendment. Now, I know you know this, but it's hard to amend the Constitution. You need 2/3 majority in the House and the Senate, and then you send the amendment to the states where 75% of the state legislators must ratify it. Now, I don't know if you'll buy this, but my opinion is you couldn't get 2/3 of Congress to agree that water is wet, let alone 38 state legislatures. So the Army proposal, when it arrived at Congress, it was dead on arrival. But you know what? It didn't fix the problem. National Guard leaders were relentless in this post-World War I period. They were offended by the way the Guard was treated. Not because they served in World War I, they wanted to serve, they were proud to serve, they had served brilliantly. They were offended because they believed the militia should have been treated equally. Rank and unit structure mattered passionately to members of the National Guard. Imagine earning the rank of captain in the militia in your National Guard and being drafted as a civilian. Now, it took over a decade, but National Guard leaders continued to press for a solution that was equitable. What did they want? Guard leaders believed that the National Guard should not have to be drafted. Instead, they argued and advocated that the Guard should simply volunteer in advance for federal service when needed with the Army, and in this sense, always ready, always there to serve in the Army. This was settled in 1933. Congress amended the 1916 Act. They created the National Guard of the United States, a federal reserve of the United States Army. Henceforth, there would be two National Guard organizations, the National Guard of the States and the National Guard of the United States. These are legally distinct, but overlapping. Please note this was a NGAUS initiative backed by NGAUS and the states and the United States Army. Beginning in 1933 and still today, when you join the National Guard, you join both organizations. The new law required the Army to federally recognize the individual rank and the unit structure of the National Guard. This meant that when drafted for future service, you would serve in the Army, but at the rank you had earned in the militia and as part of the same unit as you did in the National Guard. The National Guard also became, by virtue of this law, the primary combat reserve of the United States Army. When mobilized for federal service, members or units are still discharged from the state organization. However, after federal service, they return to their status in the National Guard. No longer a one-way ticket, now it's a round trip. This was used to full effect in World War II as almost the entirety of the National Guard was mobilized. They performed brilliantly, serving with our Army in Europe and in the Pacific. After World War II, the Air Force was created in 1947, and with it came the Air National Guard, and they are bound by the same rules we just discussed. It is my sincere hope, now that Space Force has been established, that Congress will soon establish a Space National Guard, and it too will follow the same rules. Now let's pause for a second and just think about what happened in 1903, 1916, and 1933. In 1903, Congress used its militia power to organize the militia, create the National Guard, and they provided substantial resources. They provided. In 1916, they used their war power to raise an army by deciding that the National Guard could be drafted as individual citizens. And in 1933, they bridged the militia and war power, creating this new armed forces organization, the National Guard of the United States, and linking it to the existing National Guard organization from the Constitution. But understand, the Constitution did not change. Nothing was amended. So, imagine being a new officer today. You join the National Guard. What happens? The governor gives you a commission. In accordance with the Constitution, it's a militia commission. You're required by the 1933 law to join the National Guard of the United States. Unless found unfit for service, the Army or Air Force must federally recognize you. And then you get a second commission, a Federal Reserve Commission in the Army or the Air Force. And while you're always in both organizations, you only serve in one at any given time. You join the State Guard first, and you only serve in the National Guard of the United States when you have been federalized. This completed this period of transition, and this is largely our law today. Now, I've made the point multiple times that the National Guard, unless it's federalized for federal service, is under the state's command and control. I've also commented that Congress, at least since 1903, has provided substantial money to train and organize the National Guard. But we must always remember that these funds are not a grant. Billions of dollars are provided annually, and the states, through the adjutants general, are responsible for every dime. In fact, Congress created the National Guard Bureau, part of the Pentagon, which has the express purpose, among many, to ensure that these funds are well managed. If they are not, they can remove federal recognition. They can prohibit the use of federal funds. The National Guard Bureau is federal. It's important. It has authority to ensure fiscal compliance. But it's not in command of the National Guard. The states are. In fact, this may shock you, but the state's power over the militia and the National Guard, and the federal government's power, has not changed since ratification of our Constitution. States have command and control until federalized, at which point the federal government has full authority until the mission's complete. There's no conflict between federal and state law. The Constitution is preeminent. Every reference we're talking about is federal. In addition to the Constitution, you can see this same framework reviewed and upheld by the Supreme Court and the lower courts. There are many cases. I can't touch on them all today. Houston versus Moore in 1820, Tarbell's case in 1872, the selective draft law cases in 1918, Perpich versus DOD in 1990, and the recent case we just talked about, Texas versus DOD. So let's illustrate how this works to foot stomp it. Day to day, the majority of National Guard personnel live active civilian lives. They report for training as required. They can be placed on state active duty for emergencies. This all occurs in a state status, which can be federally or state funded. However, the source of the funds does not change the fact that it is a state status under governor's command and control. When activated, mobilized, drafted, or otherwise called to federal service, members or units of the National Guard separate from the state organization and seamlessly assume their status in the federal government, the Army, or the Air Force. When active duty service is complete, the unit or members of the National Guard of the United States are released from federal status and return to their status in the National Guard. This is the normal status of the National Guard. This is the National Guard at rest. Now, having discussed and explained how the National Guard's story and how we got here, let me pull one more thread. There are many today who hear this story and they simply dismiss it. They say, you know, the Guard's not the same as the militia in 1789 or 1903 or 1933, and it's useless history. Despite the fact this information is accurate, it's true, it's verifiable, they adopt sort of a twisted Groucho Marx approach. Are you going to believe me or what the law says? They're really saying, the Constitution needs to be rewritten to apply to modern society. I disagree. I don't think the Constitution needs to be rewritten. It needs to be reread. Let me show you quickly some of our current laws so that you understand it's not just a history lesson, it's current law and how this framework is in our existing laws today. The Armed Forces does not include the National Guard. Despite the fact that a department like the Army or Air Force Department, it functions under the control, reserve components function under the control and supervision of a secretary, the reserve components they're talking about are the Armed Forces Reserve components, which don't include the National Guard. They include the National Guard of the United States. The National Guard, the militia, is still codified under Article 1, Section 8, and is federally recognized. The Army National of the United States is a reserve component of the Army or the Air Force. It consists of federally recognized units and individuals. When it's in the service of the United States, it's part of the Army or part of the Air Force, and when it's not on active duty in federal service, it is administered, armed, equipped, and trained in their status under the governor's command and control. What about Title 32? We maintain the National Guard as a first-line defense of the United States. Remember, you raise an Army, maintain a Navy, well, you maintain a National Guard in order to raise an Army. The Adjutant General has existed since 1789, follows the laws of the state, and the only person that can give an Adjutant General a direct order on this matter is the governor. We train to the Air Force and the Army standard. The states conduct the training. What about the Guard Bureau? It's a joint activity at DoD. It's a channel of communication between the departments of the Army and the Air Force and the states and the Adjutants General. There's a charter for the National Guard Bureau. It has to include certain things. Among them are these, including extending or withdrawing federal recognition. In summary and conclusion, let me offer some final context and opinion. President Reagan commented that freedom is not guaranteed. It must be preserved, defended, protected, one generation at a time. We're often reminded by leaders that we are a nation of laws and not men. We have a constitution, not a king. That great American poet, Bruce Springsteen, wrote, "My father said, 'Son, we're lucky in this town. It's a beautiful place to be born. It just wraps its arms around you. Nobody crowds you, nobody goes it alone.'" And you know that flag flying over the courthouse? It means certain things are set in stone. Who we are, what we'll do, and what we won't. Now, the Gipper and the Boss are largely saying the same thing. We are all Americans. We are blessed to live in a republic under a constitution. It provides us all with equal protection under the law. We have the ability to change that law whenever we think it's necessary, and a shared faith that our elected officials and institutions that we create will preserve our republic for us and future generations. The National Guard is one of those institutions. It is noble, it is trustworthy, it is constitutionally unique. It has a twofold mission: primary combat reserve and first military responder in the homeland. It's a modern marvel. Our nation has invested substantial combat power for our Army and our Air Force in the National Guard, but despite F-35s and modern artillery systems and tanks, it's not the equipment that makes the Guard special, it's the people who serve in the National Guard that make it special. Today's National Guard is a modern embodiment of the Minuteman, the same patriots who fired that shot heard around the world. Why? The men and women who serve in the National Guard are not farmers, but they all have a plow. The plow represents their chosen livelihood, their family, their community. Represents every possible career path chosen by an American. It includes firefighters, law enforcement officers, doctors, nurses, truck drivers, students, teachers, factory workers, and okay, some farmers. But the list goes on and on. Despite the diversity of these various walks of life, these patriotic souls all share the National Guard service at their very core. They don't carry a musket today, but they all have a musket. The musket represents their military occupation, their skill set. National Guard personnel have earned every possible Army or Air Force qualification, including military medicine, aviation, armor, artillery, infantry, cyber, space, transportation, security, logistics, and the list goes on and on. These patriots are 100% American soldier or American airman, but they are much more. They live in our communities, they respond to the governor's call for any emergency, and they stand as an integral part of our Army and our Air Force whenever we need to fight anywhere on this planet. If you're talking about America, you're talking about the National Guard, which is part of the very fabric of this nation. And I'm proud to be a member of NGAUS and represent that organization. Thank you, ladies and gentlemen. Thank you. Thank you very much. Thank you, sir.
Thank you, Don. Thank you,
Pick up my
Don.
mess here.
So Don is going to take some time at the Minuteman stage, which is in the back corner, for those of you who may have questions. I will tell you that as a TAG for the past 7 years, this foundation of information is a great reference point for decisions that I make as a TAG. And I think it's important for you to understand this foundation. And so please take some questions back and ask about how it applied to COVID and how the TAGs responded and those kind of things. There are a lot of issues out there right now that we're facing as the National Guard that this fundamental information addresses. So General Dunbar will be available to you back on the Minuteman stage. Please engage him with some questions so you can fully understand how this is applied today. Major General Dunbar, thank you for your presentation. Thank you.